Hi, and welcome to Hull and Hull TV. I'm Dana O'Brien, and I'm joined by Ian Hull and Suzana Popovic-Montag, partners at Hull and Hull LLP, an innovative law firm that practices exclusively in estate, trust, and capacity litigation. Here at Hull and Hull TV, we're exploring the issues around estate planning that affect you. And one of those issues is compensation for a trustee, executor, or attorney. Ian, they all have very different roles, so how do you determine how each should be compensated? Is there a formula?
Well, the different roles do determine a little bit on how you're being paid. For example, an attorney under a power of attorney in Ontario, there's a statutory formula that you start with. And it's a little more than you get paid a little bit more than you do as a trustee for an estate or a trust, an ongoing trust. So there is a formula that the courts will say that's where you start, but then they double check it and they want to know, first of all, how well you've done, how much has been involved, how big are the assets in terms of amounts involved, that kind of thing, any risk that was involved. So there's a factoring in of that as well.
What happens if the compensation is greater than the actual effort? That can be a problem, can't it, Suzana?
Yes, it sure can. And we've seen many disputes where people will say that there should actually be no compensation at all, let alone what amount is being claimed and what they might otherwise be entitled to. In these cases, what will typically happen is that the executors or the trustees or the power of attorney's accounts will be assessed with the hope that they'll be able to reduce the claim for compensation either voluntarily or by order of a court.
Ian, how common is it for compensation to be challenged, and on what basis?
Well, it's relatively common, I would say. It's not every case, but lots of times people want to question not just the amount, but how the administration was conducted of the assets. So compensation gets affected by that. I mean, if you performed well, as anything in life, you perform well in your job, then you should be compensated at the sort of set salary or that formula basis is the way the courts will often approach it. But they also want to know a little bit about what you were performing with, what kind of problems that may or may not have been created, and how does that affect your bottom line in terms of how much you're going to get paid. We find that compensation is a very, very contentious issue in the sense that when someone wants to attack you, it is almost always the first line of attack when you've acted as an attorney because they know that hits you in the pocketbook. They know it's money out of your pocket.
Suzana, what are some of the reasons people might dispute the compensation?
I think there's probably three main reasons for disputing compensation. The first one sort of starts with the nature of the appointment. If it's a family member, then other family members may think that, there should be no claim for compensation. They should do this basically for free. There could also be an element of dissatisfaction with the way that the administration has been run, with the hope that as a result of that, they'll be able to reduce the compensation. And in some cases, it may be felt that the effort that was involved may be completely disproportionate to the amount that's ultimately being sought.
How important is it then for a family to have a clear understanding of the compensation? And Ian, when should that conversation take place?
Well, I think it's crucial because it is a source of tremendous tension when anybody does something for their family and expects to get paid. It's sort of like cutting the grass. You're not supposed to get paid or you should get your allowance for it. And everybody wants to undermine their effort and then nobody wants to be seen to be letting one member get more than the other. If it's an equal distribution estate, it looks like someone's getting more than the other. So those kinds of tensions play out in these things in real life and they're not insignificant. So that conversation is, first of all, it's really easy to have because there are clear parameters. It's about 5% of the asset that you're available to you to get paid as an executor or a trustee. It varies, and it can go up to 6% as a power of attorney. It can go down depending on the conduct of your administration. But let's have those discussions. I say to my clients all the time, have them early and often so that somebody understands, okay, I've got like a real estate commission. It's going to get paid. Someone's going to have to work very hard to make that happen. And it's not because I like you less or I like you more. It's because it's a big job, and I want them to take it seriously, so I want to pay them fairly.
Ian and Suzana, good advice. Thank you. And thanks for joining us on Hull and Hull TV.